As the MEC for Human Settlements in Gauteng, it's my responsibility to address the pressing issues of land invasion, unlawful occupation, and the overarching need for adequate housing in our province. Over the past 15 years, Gauteng has witnessed a significant rise in land invasions, a phenomenon that poses unique challenges given our province's socio-economic landscape. While it is common cause that the challenges related to land and property invasions vary across provinces due to diverse jurisdictional factors, our primary focus today is to analyze these challenges within the context of Gauteng. To understand the importance of reviewing the PI Act, we must trace the origins of this legislation within our broader constitutional framework. The Republic of South Africa, as a constitutional state, is founded upon critical values such as human dignity, equality, and the advancement of human rights and freedoms. All arms of the state, including national and provincial governments, must work collaboratively to realize these values and ensure the constitutional rights of our citizens. The right to adequate housing is intrinsically linked to the right to human dignity, as espoused in our Bill of Rights, Section 26 of the Constitution, which asserts, 1, that everyone has the right to have access to adequate housing, and 2, the state must take responsible legislative and other measures within its available resources to achieve the progressive realization of this right. As the MEC of Human Settlements, I have an inherent constitutional obligation to provide adequate housing to the citizens of Gauteng. The responsibility extends to developing sustainable human settlements that align with our constitutional mandate. The PI Act was enacted to prevent illegal evictions and unlawful occupations while balancing the rights of landowners and occupiers. However, it has become evident that a legislative lacuna within the PI Act impede our ability to deliver on our constitutional obligations effectively. The PI Act provides a framework for the eviction of unlawful occupiers and aims to protect vulnerable individuals from arbitrary evictions. Some critical provisions include that landowners must provide adequate notice to unlawful occupiers before initiating eviction proceedings, that evictions can only be conducted under a court order, ensuring that due process is followed, and the Act emphasizes the need to protect vulnerable groups, including women and children, from unlawful eviction. Several court cases have highlighted the importance of the PI Act in protecting the rights of unlawful occupiers. For instance, the Port Elizabeth Municipality versus various occupiers case reaffirmed the necessity of adhering to the provisions of the PI Act, ensuring that evictions are conducted lawfully and fairly. There have been many challenges to implementation. Despite the framework provided by the PI Act, several challenges hinder its full implementation in Gauteng. Firstly, the lack of adequate resources and capacity within municipalities limits their ability to enforce the provisions of the PI Act effectively. Secondly, the growing demand for housing, compounded by economic challenges, has led to increased land invasions as people seek shelter. Thirdly, the legal processes involved in evictions can be cumbersome and lengthy, often leaving vulnerable occupiers in precarious situations for extended periods. Fourthly, high levels of unemployment and poverty in Gauteng contribute to land invasions as individuals seek immediate solutions to their housing needs. And last but not least, land invasions can be influenced by political interests and community dynamics, complicating the resolution of disputes. To address these challenges, it is crucial to propose amendments to the PI Act that enhance its efficacy. These may include simplifying and streamlining the eviction process to ensure quicker resolutions while protecting the rights of all parties involved. It could also include allocating more resources to municipalities to enable effective implementation of the PI Act, as well as educating communities about their rights and the legal provisions of the PI Act, fostering a culture of compliance, and partnering with non-governmental organizations to provide support and resources to vulnerable communities facing eviction. In conclusion, the review of the PI Act is not merely an administrative exercise. It is a critical step towards fulfilling our constitutional obligations to the people of Gauteng. As we move forward, let us remain committed to ensuring that the right to adequate housing is realized for all our citizens. Together, we can address the challenges of land invasions and unlawful occupations, fostering sustainable human settlements that honor the dignity of every individual. Thank you very much.